law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant he has been charged with offenses. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. For each offense charged in the indictment, the defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of that offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If, after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt, and you must find the defendant guilty of that charge. If you are not firmly convinced of the truth of that charge, you must find the defendant not guilty of that charge. Oshay Jordan has chosen to represent himself. He has a constitutional right to counsel. He also has a constitutional right to represent himself. The fact that he has chosen to represent himself should not influence you in any way. The court has assigned attorney Allison Hibbard to assist defendant Oshay Jordan upon request. Evidence is all the testimony received from the witnesses, the exhibits admitted during trial, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. If you awake in the morning and you see the ground is covered with snow, that is circumstantial evidence that it snowed earlier. If you see human footprints in the sand, that is circumstantial evidence that someone had walked there. To infer or to make an inference is to reach a reasonable conclusion of fact, which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight and probative value. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Some exhibits may appear to have been deleted, redacted, or omitted. There is nothing improper in any deletions, redactions, or omitted material, and no one has tampered improperly with such evidence without the knowledge of the state, the defense, and the court. In fact, such deletions, redactions, or omissions have been done at the request and agreement of both parties. Any material that has been deleted, redacted, or omitted is irrelevant to your determination on the issues in this case. You are to infer nothing by what you think may be deleted, redacted, or omitted. Do not conjecture or speculate on what was not presented to you in the exhibits. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may use the tests of truthfulness which you use in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the accuracy of the witness's memory, frankness or lack of it, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. By using these tests, you may assign to each witness's testimony such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that he did not testify must not be considered for any purpose. Police officers have testified in this case. You are not to give any greater or lesser weight to their testimony based solely on the fact that they are police officers. In count one, the defendant is charged with having a weapon under disability. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June, 2024, in Lake County, Ohio, the defendant knowingly had a firearm and the defendant had been previously convicted of felonious assault in the Lake County Court of Common Pleas, case number 08CR000271, dated December 23, 2008. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. Had means possessed. A person has possession when he knows that the object on or about his person or property, or places it where it is accessible to his use or direction, and he has the ability to direct or control its use. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable, but that can readily be rendered operable. When determining whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant, the trier of fact must rely upon circumstantial evidence, including but not limited to the representations and actions of the individual exercising control over the firearm. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon or possessed, carried, or used as a weapon. Evidence was received that the defendant was previously convicted of felonious assault. That evidence was received because of a prior conviction is an element of the offense charged. It was not received, and you may not consider it to prove the character of the defendant in order to show that he acted in conformity with that character. If your verdict is guilty on having a weapon under disability, you will also decide another issue. The state of Ohio claims that any right, title, or interest of the defendant in the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio. You will sign a verdict finding that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture if you unanimously find by clear and convincing evidence that the property was 1, contraband involved in the offense of having weapon under disability, or 2, an instrumentality that was used or intended to be used in the commission or facilitation of the offense of having a weapon under disability, and the use or intended use was sufficient to warrant or justify the forfeiture of that property. If your verdict is not guilty on having a weapon under disability, you will not decide the additional issue about the forfeiture of the pipe, cocaine, firearm, magazine, ammunition, and marijuana. Clear and convincing evidence is evidence that produces in your mind a firm belief or conviction about the issue in question. It must be more than evidence that simply outweighs or overbalances the evidence opposed to it. Contraband means any property that is illegal for a person to acquire or possess under a statute, ordinance, or rule, or that a trier of fact lawfully determines to be illegal to possess by reason of the person's involvement in an offense. Instrumentality means property otherwise lawful to possess that is used or is intended to be used in an offense. An instrumentality may include, but is not limited to, a firearm, a mobile instrumentality, a computer network, a computer system, computer software, a telecommunications device, money, and any other means of exchange. In deciding whether an instrumentality was used or intended to be used in the commission or facilitation of the offense of having weapon under disability in a manner sufficient to justify its forfeiture, you must consider any of the following factors that you decide are relevant. A, whether the offense of having a weapon under disability could not have been committed but for the presence of the instrumentality. B, whether the defendant's primary purpose in using the instrumentality was to commit the offense of having a weapon under disability. And C, the extent to which the instrumentality furthered the commission of the offense of having a weapon under disability. In count 2, the defendant is charged with having a weapon under disability. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June 2024 and in Lake County, Ohio, the defendant knowingly had a firearm and the defendant had been previously convicted of possession of cocaine in the Lake County Court of Common Pleas, case number 08-CR000271, dated December 23, 2008. Knowingly, had, possession, firearm, and deadly weapon have the same definitions as in count 1 above. Evidence was received that the defendant was previously convicted of possession of cocaine. That evidence was received because a prior conviction is an element of the offense charged. It was not received, and you may not consider it to prove the character of the defendant in order to show that he acted in conformity with that character. If your verdict is guilty on having a weapon under disability, you will also decide another issue. The state of Ohio claims that any right, title, or interest of the defendant in the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio. You will sign a verdict form, a verdict finding that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture if you unanimously find by clear and convincing evidence that the property was 1, contraband involved in the offense of having a weapon under disability, or 2, an instrumentality that was used or intended to be used in the commission or facilitation of the offense of having a weapon under disability, and the use or intended use was sufficient to warrant or justify the forfeiture of that property. If your verdict is not guilty on having a weapon under disability, you will not decide this issue about the forfeiture of the pipe, cocaine, firearm, magazine, ammunition, and marijuana. Clear and convincing evidence, contraband, and instrumentality have the same definitions as in count 1. In deciding whether an instrumentality was used or intended to be used in the commission of or facilitation of the offense of having a weapon under disability in a manner sufficient to justify its forfeiture, you must consider any of the following factors you decide are relevant. Whether the offense of having a weapon under disability could not have been committed but for the presence of the instrumentality. B, whether the defendant's primary purpose in using the instrumentality was to commit the offense of having a weapon under disability. And C, the extent to which the instrumentality furthered the commission of the offense of having a weapon under disability. In count 3, the defendant is charged with possession of cocaine. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June, 2024, and in Lake County, Ohio, the defendant knowingly obtained, used, or possessed cocaine or a compound, mixture, preparation, or substance containing cocaine, a Schedule II controlled substance. Knowingly has the same meaning as in count one. Possess or possession of drugs means having control over such a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. Ownership is not necessary. A person may possess or control property belonging to another. Possession of drugs can either be actual or constructive. Actual possession exists when the circumstances indicate that a person had cocaine or a compound, mixture, preparation, or substance containing cocaine within his immediate physical control. Constructive possession exists when a person was aware of the presence of cocaine and was able to exercise dominion and control over that cocaine, even though that cocaine may not have been within his immediate physical control. Both dominion and control, and whether a person was aware of cocaine, may be established through circumstantial evidence. Thus, the state may establish constructive possession by circumstantial evidence alone. If your verdict is guilty on possession of cocaine, you will also decide another issue. The state of Ohio claims that any right, title, or interest of the defendant in the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio. You will sign a verdict finding that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture if you unanimously find by clear and convincing evidence that the property was, one, contraband involved in the offense of possession of cocaine, or two, an instrumentality that was used or intended to be used in the commission of or facilitation of the offense of possession of cocaine, and the use or intended use was sufficient to warrant or justify the forfeiture of that property. If your verdict is not guilty on possession of cocaine, you will not decide this additional issue about forfeiture of the pipe, cocaine, firearm, magazine, ammunition, and marijuana. Clear and convincing evidence, contraband, and instrumentality have the same definitions as in count one. In deciding whether an instrumentality was used or intended to be used in the commission of an offense or facilitation of the offense of possession of cocaine in a manner sufficient to justify its forfeiture, you must consider any of the following factors you decide are relevant. A, whether the offense of possession of cocaine could not have been committed but for the presence of the instrumentality. B, whether the defendant's primary purpose in using the instrumentality was to commit the offense of possession of cocaine. And C, the extent to which the instrumentality furthered the commission of the offense of possession of cocaine. In count four, the defendant is charged with soliciting. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June, 2024, and in Lake County, Ohio, the defendant knowingly solicited another to engage in sexual activity for hire in exchange for the person receiving anything of value from the defendant. Knowingly has the same meaning as in count one. Solicited means to seek, to ask, to influence, to invite, to tempt, to lead on, or to bring pressure to bear. Sexual activity means sexual conduct or sexual contact, or both. Sexual conduct means vaginal intercourse between a male and female, anal intercourse, fellatio, and cunnilingus between persons regardless of sex, and without privilege to do so, the insertion, however slight, of any part of the body or instrument, apparatus, or other object into the vaginal or anal opening of another. Penetration, however slight, is sufficient to complete vaginal or anal intercourse. Sexual contact means any touching of an erogenous zone of another, including without limitation the thigh, genitals, buttock, pubic region, or if the person is a female, a breast, for the purpose of sexually arousing or gratifying either person. Sexual activity for hire means an implicit or explicit agreement to provide sexual activity in exchange for anything of value paid to the person engaging in such sexual activity, to any person trafficking that person, or to any person associated with either such person. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find that the state failed to prove beyond a reasonable doubt any of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. It is alleged that the offenses took place on June 20, 2024. It is not necessary that the state prove that an offense was committed on the exact date as charged in the indictment. It is sufficient to prove that the offenses took place on a date reasonably near the date claimed. You will have with you in the jury room the following verdict forms, one for each count. Each states, "We, the jury, being duly impaneled and sworn, find the defendant," and then there is a blank. You will fill in either guilty or not guilty according to your findings. There is a place for 12 signatures. Your verdict must be unanimous, and all of you must sign the verdict form in ink on the line next to your juror number. Counsel will now present their closing arguments. The state will go first, followed by the defense, and then the state will have the last opportunity to address you since they have the burden of proof. Ms. Wood?
Thank you, Your Honor. Ladies and gentlemen of the jury, thank you for your time and attention to listening to the presentation of the testimony over the past couple of days. In this case, you heard about a lot of testimony that you probably didn't expect to hear. You heard testimony about a gun, about drugs, sex, and prostitution. In my opening statement, I told you that this was a chaotic scene. There was screaming, there was a physical altercation that led to the arrest of all three individuals: the defendant, Destiny Thomas, and Kashonda Lewis Ganell. I asked you in opening to look past all the chaos and focus on what the elements are and what the defendant is charged with. We heard from several officers who responded that night on June 20th. Officer Brown was the first responding officer and his backup officer, Officer Lampola. We also heard from Lieutenant Crowley. We then heard a lot of testimony about the process that the Detective Bureau did at the defendant's apartment that night when executing the search warrant, where they found a firearm, ammunition, cocaine, the pipe, and marijuana. We then heard testimony from several people from the Lake County Crime Lab. They testified about their process of receiving the evidence, the process that all the evidence was tested, and what their results were. And you also heard from Destiny Thomas and Kashonda. They were very candid, blunt, frank. Now, you don't have to agree or like or approve of the behavior that they engaged in that night. Their lifestyle and their choices may not be something that is approved by society that people like, but it's the fact of what happened here. And they were presented to you because the state doesn't hide from the truth. They came in here, Destiny by video, and they told you what they saw, what they heard, what they observed, and how they felt. They told you what the agreement was that night, why they were going to the defendant's apartment, and what happened inside that bedroom. The defendant is charged with 4 counts. He's charged with having weapons under disability, He's charged with possession of cocaine, and he's charged with soliciting. For all of the counts, these three things apply: that it occurred in Lake County, Ohio on June 20th, 2024, that it involved the defendant, Mr. Oshay Jordan. Now, count one, having weapons while under disability. Knowingly had a firearm and has a prior conviction for felonious assault. We know he had a firearm because both Destiny and Kashonda testified about that. There was a firearm located in State's Exhibit 11, and you heard testimony from Jordan at the crime lab. And you heard testimony from Lieutenant Burgett that he had a prior conviction for felonious assault. Now, the element of knowledge is defined in the jury instruction in count one, and it applies throughout all of the counts. A person is aware that their conduct will probably bring a certain result. We know that the defendant was aware of it because it was in his gun, in his hand, and his DNA was on it. All of the same evidence for count one applies to count two. The only difference in count two is the possession of cocaine charge as opposed to a felonious assault conviction. Now, you received that testimony like the judge just instructed because it's an element of the offense. It is not important, and there was no testimony about any of the details of those prior convictions because that is not what's at issue here. What you are to consider is just solely the fact that he has those prior convictions, and that's it. The defendant's DNA was on the firearm and magazine, and the DNA analysts testified about what that result was and that it was a very strong association. We brought in people from the maintenance department at Parkway Apartments and the leasing manager. That was the defendant's apartment. There were no other people that lived there. There were no other beds in the apartment. The defendant's belongings were in there. He knew he had that gun, and two witnesses saw him waving that gun around. He did not point it at anyone. He did not threaten anyone. But he pulled it out, and he made sure that both of them knew it was there. As I said, count two is the exact same evidence as in count one. Knowingly had a firearm. The difference is the prior conviction is for possession of cocaine. All of the same evidence. You saw pictures of the apartment that the maintenance personnel took when the defendant left his apartment. You saw the picture of his air mattress on the ground. And over top of that air mattress was a metal bed frame. It was referred to as a headboard, a shelf. And you also saw pictures, and we put the map up of the layout of the apartment, of what that apartment looked like, where everything occurred, where people were standing approximately, and where the evidence was found in the defendant's bedroom. Count three is possession of cocaine. Knowingly obtain, possess, or use cocaine, a Schedule II controlled substance. We heard testimony from the detective bureaus that they found a pipe in the defendant's bedroom, and they found loose rocks, the white substance. Both of those contained cocaine. The pipe contained residue, and the other loose cocaine was 0.11 grams. You heard testimony about the testing process at the Lake County Crime Lab to look at those pieces of evidence and come to their conclusion. And Destiny and Kashonda both saw the defendant use the cocaine by inserting the pipe into his mouth. Kashonda said it happened a few times, and blowing the smoke out. You also heard testimony about the defendant's DNA being on the pipe. 30 septillion times more likely if the mixture on the pipe is the defendant and an unknown person than two unknown people. Makes sense that his DNA would be on the pipe. The crime lab testified that they swabbed both ends of it. and Destiny and Kashonda saw him use it and insert it into his mouth. Kashonda also testified that there was cocaine, or she referred to it as crack, all over the room, on his shelf, on his pillow, on his kneecap, and it was found in his bedroom that night. Soliciting, count 4. Knowingly solicit another to engage in sexual activity for hire and to receive a value or benefit from the defendant. There was testimony about how Destiny and Kashonda advertised themselves. They posted on websites or applications saying that they were in the area, a way to contact them, and that's exactly what the defendant did. There was testimony that there was a phone call, there was a discussion that they were going to come to the apartment and meet with the defendant. They both testified it was 2 girls for 1 price. And this is the testimony that I was talking about earlier in my opening. You don't have to agree or approve of it. In fact, Kashonda even said in her testimony, it was bad enough we were selling our bodies. But that's what happened here. And the state presented it to you because it's part of this case and we don't hide from the truth. There was testimony about what these escort websites entail. And both of them testified that their intention going there was to have sex with the defendant. There was also a lot of testimony about what they were going to receive. In today's day and age, there was no cash exchanged. It was all sent by the application called Cash App. Send money from one phone to another. They both testified they got paid. They split the money. And Kashonda stated that Destiny performed oral sex on the defendant. There's a lot of background noise and chaos in this case. And I urge you to reread the jury instructions and focus on the elements that the state has to prove. This case is not about the chaos or yelling. It's not about Kashonda's charges. It's not about Destiny's charges and whether or not they quote unquote robbed or stole from the defendant. This is not about any prior legal proceedings prior to trial. This is not about the validity of a search warrant at the defendant's apartment or the validity of a search warrant to obtain his cheek swab. This is not about how long to the exact minute that people were on scene or who drove who back to the police department. Those are not elements that the state has to prove. This is not about stealing from the defendant. You're not here to determine any charges for Kashonda or Destiny. This is the state of Ohio versus Oshay Jordan. He's not charged with theft. He's not charged with holding anyone against her will. There's testimony that Kashonda needed her phone. Yes, she couldn't get out because the door was rigged. It was difficult to open, but she was not leaving without her phone that night. I urge you and submit to you that the state has proved its case beyond a reasonable doubt as to every element as charged. And what he's charged with is count 1, having weapons under disability, knowingly have a firearm, and has a prior conviction for felonious assault. Count 2, the same evidence, having weapons under disability. The difference is that prior conviction is for possession of cocaine. Count 3 is possession of cocaine, and that's based on the pipe and the loose cocaine that was collected in his apartment. And count 4, soliciting. Knowingly solicit another to engage in sexual activity for hire and for them to receive a value or benefit from the defendant. Now I put a star here in the words forfeiture specification. Means that if you find the state has proved its case as to the counts that contain a forfeiture specification, that the defendant forfeits his right, title, or any interest in that property that was collected. Look at the evidence that we have here. Re-listen to the 911 calls of Kashonda and Destiny screaming, calling for the police to come that night on June 20th. Look at the firearm, look at the cocaine, look at the pipe. Look at the pictures that we submitted to you and compare them to what the testimony was of the Detective Bureau that night and finding that. And remember, this was the defendant's apartment. There was no other person that was living there with him. Kashonda and Destiny did not see anyone else that night. They locked the door with the defendant after they accompanied him upstairs to get a pair of shorts. There was a different type of lock on the door that was not typical of other units in that building. And they used the key several hours later that same day, about 9:45 a.m., to go into his unit and find these items. And they were exactly how Kashonda and Destiny described them. The state has proven its case beyond a reasonable doubt as to every element of the offenses charged here, and I ask that you find the defendant guilty. Thank you.
Thank you. Mr. Jordan?
Ladies and gentlemen of the jury, just want to start by just thinking out loud, because if the door was one that was so rigged that's been repeated and included in the closing argument, I do believe there would have been pictures taken of a rigged door supporting any claim that would be stated as such. But nonetheless, again, ladies and gentlemen of the jury, I do again stand here before you today seeking the extended hand of justice. Prior to this claim, prior to officer obtaining a legal warrant, law enforcement did in fact search my home, as well as allowing individuals who were not residents to remain in my home as I sat in a police cruiser. And may I remind you that no crime had been committed, and that the true reflection really is to what extent of constitutional violations in order to create such a crime. Because of the illegal search and seizure, the prosecution has presented to you evidence in which at face value, some would assume to be a crime. But because of my 4th, 5th, and 14th Amendments rights being compromised, I was not afforded a due process of law, as well as an attorney who sought justice as I did. I urge for you to simply consider what is fair and what is just. Because of these violations do not only affect me, but they do have a greater impact upon society, meaning all citizens, as well as the integrity of the legal system at large. Again, ladies and gentlemen of the jury, I urge for you to consider the evidence in light of constitutional violations. And once more, I urge for you to render a verdict that respects and reflects legal rights, our legal rights and principles of justice. And thank you for your attention.
Thank you. Ms. Alessi?
Thank you, Your Honor.
Good morning, ladies and gentlemen of the jury. When Ms. Lewis-Gannell testified yesterday, I think she perfectly summarized the events leading up to this. This was an escort gone bad. As Ms. Wood stated, and as you heard over the last couple days, there was a lot of chaos leading up to the events that happened here. It was a chaotic scene, and as a result of that, you heard from a lot of witnesses over the past couple days, and we appreciate your time and attention in listening to those witnesses and everything they had to say. I know it may have seemed tedious at times, but it was important. It was important for the state to prove, for you to hear that evidence in order for the state to prove each and every element of these offenses beyond a reasonable doubt. And despite that chaos, despite everything going on scene, what you are asked to do today is very straightforward. You are here to determine if the defendant knowingly had a firearm when he wasn't allowed, if the defendant knowingly possessed or used cocaine, and if the defendant knowingly solicited another to engage in sexual activity in exchange for that person receiving something of value. Briefly, I want to talk about the having weapons while under disability counts. The defendant can be convicted of both of those counts. It is charged alternatively, so that if you find that the state has proved each and every element of those offenses beyond a reasonable doubt, you can find him guilty of both of them. If you find him guilty of one, that would not preclude you from finding him guilty of the other. I just wanted to make that clear. Sometimes that can be confusing. Here, for both counts, we're talking about the same facts, the same gun, the same night, and the same prior conviction. To address what the defendant came up here and stated, this is my full circle moment when I bring you back to what we talked about in voir dire Tuesday morning, these collateral matters, things that are not elements that the state has any burden to. The search of the defendant's home is a collateral matter. The constitutional alleged violation, that's a collateral matter. Even to consider what is fair and just, that is not what you are tasked with here today. As we talked about in voir dire on Tuesday, the state has no burdens as to these collateral matters. Any alleged violation of the defendant's rights or unlawful search, those are matters of law. That is Judge O'Donnell's job. That is not your job. And the jury instructions that the judge provided you, you will see nowhere in there are you asked to decide those matters. You are asked to evaluate the evidence and apply the law and determine the defendant knowingly possessed a gun or knowingly had a gun, knowingly possessed cocaine, and knowingly solicited Ms. Thomas and Ms. Lewis-Gunnell for sexual activity in exchange for money. I want to talk about this kind of in reverse chronological order, talking about the soliciting first. You will see in the jury instructions you were provided that the law does not require the sexual activity to actually have occurred. All that the law requires is that the defendant knowingly solicited the women to engage in sexual activity. And Ms. Thomas and Ms. Lewis-Gunnell both testified that they were solicited to come to the defendant's apartment by the defendant to engage in sexual activity. Both testified that they were there for a two-girl special. Ms. Thomas and Ms. Lewis-Gunnell's testimony differed as to whether or not sexual activity was actually performed in that apartment. But again, the law doesn't require the state to prove that sexual activity would have occurred. And it is up to you to weigh and determine the credibility of each witnesses. Why might Ms. Thomas not want to say that she had performed fellatio on the defendant? Could she have been embarrassed? It's for you to decide. But Ms. Thomas and Ms. Lewis-Gunnell, they didn't know the defendant. They never met him before. They had no motivation to lie here. In fact, they told the truth to their detriment. Both women were arrested that night and convicted of engaging in prostitution.
Object, Your Honor.
Overruled.
On scene, both witnesses were telling officers and testified here today that the defendant had a gun in his apartment. Both women testified the defendant was smoking crack from a crack pipe in his apartment. When the Willoughby Police Department obtained a search warrant and searched the defendant's apartment, they found the firearm and the crack. And not only did they find the drugs that the defendant was smoking, they found them in the exact location where Ms. Lewis-Gunnell testified that she saw him grabbing them from. In State's Exhibit 10C, it was on the shelf and that kind of makeshift headboard behind the defendant's inflatable mattress. When officers asked the defendant for consent to search his apartment that night, he wouldn't give it to them. We heard from Kelly Reese with the Lake County Crime Lab, who analyzed the DNA in this case. And the DNA here on the pipe was a match to the defendant. She testified that it was a very strong association. And she also testified that the defendant's DNA was located on the firearm. And not only was his DNA located on the firearm, scattered throughout his apartment were magazines, ammunition, and boxes of ammunition. Ladies and gentlemen, we are here to focus on the actions of the defendant, not the actions of law enforcement and not the actions of Ms. Lewis-Gunnell or Ms. Thomas. It is the actions of the defendant and what the defendant did on June 20th of 2024. The state has proved each and every element beyond a reasonable doubt, and we ask that you find the defendant guilty on all counts. Thank you.
Thank you. All right, ladies and gentlemen, we'll pick back up on near the bottom of page 11 if you want to follow along in the instructions. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in the light of and in harmony with all the other instructions. The court has instructed you on all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts. If you have an impression that the court has indicated how any disputed fact should be decided, you must put aside such an impression because that decision must be made by you based solely on the facts presented to you in the courtroom. You may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. Circumstances in the case may arouse sympathy. Sympathy is a common human emotion. The law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. When you go to the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than any other jurors. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and any exhibits are returned to the court after you have reached a verdict. If you took notes during the trial, you may take the notes to the jury room. The fact that notes taken by a juror support his or her recollection in no way makes his or her memory more reliable than that of jurors who did not take notes. All notes would be returned to the bailiff for destruction when the jury is discharged. The court will place in your possession the exhibits, a copy of the jury instructions, and the verdict forms. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, do not surrender honest convictions in order to be congenial or based solely on the opinion of other jurors. In order to return a verdict, it is necessary that all jurors agree. It must be unanimous. Your verdict must be based solely on the evidence and on the law as the court has given it to you during the. Nothing that the court has said or done is intended what your verdict should be. That is entirely for you to decide. If you have any question or request during your deliberations, your foreperson should write that question or request and notify the bailiff so the question or request to me. The court cautions you, however, any message or questions that you might send reveal your numerical division at that time or the status of your deliberations. It should be reduced to writing so there will be no misunderstanding as to what you request. It should then be delivered to the bailiff, who will submit it to the court. Whenever all 12 jurors agree upon a verdict, you will sign the verdict in ink on the line next to your juror number and advise the bailiff by using the buzzer in the jury room. You will then be returned to the courtroom. As mentioned earlier, you have heard all the evidence. It is common practice when jurors commence deliberations to request transcripts of various witnesses. There are no transcripts. Juror number 6, you were selected to serve in the event of any misfortune to any member of the panel. At this point, you will not accompany the jury to the jury room or participate in deliberations unless directed by the court. Please remain in the courthouse until the court directs you that it will not be necessary for you to serve any further. You are not to discuss the case or tell anyone how you would have voted until the jury has returned a verdict. After you are discharged, you may discuss your verdict and your deliberations with others, but you are not required to do so. You must decide for yourself whether or not you will discuss such matters. It is a lawyer's duty to protect your desire not to talk about the case, if that is your decision. It is improper and unethical for a lawyer or anyone else to harass, entice, or exert improper influence on you for the purpose of getting you to talk about the case. Once 12 members of the jury have agreed to a verdict on each of the counts and have signed the corresponding verdict forms, the foreperson will notify the bailiff and you will be returned to the courtroom. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right. You may now begin your deliberations.
Jurors, we all want to back to be the juror between juror number 6.
All right, here's your warning. I'm going to talk. You might want to turn your volume down.
All right. Is there anything else for the record from the state?
Yes, Your Honor. Yesterday, after the conclusion of courts, Ms. Solicitation and I copied all of the exhibits that were identified and admitted to the court's drive, and then we subsequently copied from the court drive to the jury drive all of the admitted exhibits to go back to the jury. We then had court IT, Deborah Urankar, come down and assist us in, actually she performed the function on the computer of locking the jury drive to be read only, so that there may be no deletions or changes to the exhibits on the jury drive. And we would just ask that the court retain both of those at the conclusion of the case.
All right. And the jury drive is where?
Is right here, so they will need a computer to observe.
And they
what
have,
is
they have one.
Okay.
So when Mr. Gonzalez comes back, give him the, or actually give it to Kathy right now. Okay, the drive.
Okay.
Okay. Anything else?
Does the court intend to send the firearm and ammunition all back with the jury?
The lock is on the firearm, correct?
Yes.
Yes, I do.
Okay.
It will go back to them. Okay. Anything else, Mr. Jordan?
No, Your Honor.
Okay.
It's not looking good for Charlie Brown. All right, I came across this nugget. Can you guys hear me? I came across this nugget when I was putting together the playlist. I think this is him. Let's take a look here. I just want to know if you guys think it's the same guy. It says a Painesville man faces up to 9.5 years in prison after a Lake County Common Pleas Court jury found him guilty Tuesday of stabbing his nephew while the two were high on crack cocaine. Oshay Jordan, 33, went to trial on Monday for cutting 31-year-old Cleophas Wynn Jr. with a kitchen knife March 3rd. Yeah, you guys think that's him, huh? That was a little nugget I had. All right. Let me see what else I got here. That's pretty nasty. That's his nephew. Just smoking a little crack with the nephew and then stab him. But I mean, the guy's name is Oshay Jordan in Lake County, Ohio. How many Oshay Jordans in Lake County, Ohio? I don't know. I'd be surprised if there was more than one. All right, everybody sent it to me. Here's a little time filler.
As honest as I can be, Your Honor, Mr. Blandino is a pain in the butt. We all know that.
Good morning.
Good morning, Your Honor. This is Mr. Blandino, Your Honor.
Is Mr. Dickerson here?
Mr. Dickerson said he can be here 15 to 20 minutes.
Okay. All right. As soon as I see him come in, I'll call it.
Thank you, Your Honor.
All right, page 14. State Nevada versus.
Okay, it's our old buddy Kim Blandino. Everybody sent it to me. Of course, the first thing I did is text Ben. And I said, Ben, did you know about that Kim was in court? He's like, oh yeah, I saw him in the elevator going to my calls in the morning. He's back at it. He files a bunch of stuff the day before his probation is terminated because he just can't get enough.
Blandino, case C341767. He's present. He's at liberty. Do you all want to make your appearances?
Mike Dickerson on behalf of the state, Your Honor. Morning, Your Honor. Joseph Gersten, 13876 for Mr. Blandino.
Some of this stuff had to do with the traffic stop, correct?
My understanding, Your Honor, it was the two passports that were, but if you remember, they had actually been, I was just trying to be, make it easy. Instead of filing a motion here and then filing a motion in the Justice Court for those, because they had been here. I know that Mr. Blandino has brought a copy of the order that I had sent
That suit is luscious. It really is.
to you down to the vault, and they said that was fine. They'd be okay with that particular order. So that's as much as I can tell you as far as that's concerned.
Okay. But everything else was from the underlying.
Exactly, Your Honor.
Okay.
Exactly. And just very simply, Your Honor, I mean, Mr. Blandino has completed everything. As honest as I can be, Your Honor, Mr. Blandino is a pain in the butt. We all know that. But this is his property. He's completed his probation. He was honorably discharged. His property should come back to him.
Well, why is the state hanging on to it?
Did you see our opposition we filed
I
yesterday?
did.
Okay, so the main reason is that for the overarching reason for all the evidence is that the defendant is consistently making attacks on the convictions that have been had in both cases, right? And so as a result, we need to preserve that evidence should there ever be a retrial. I included in there a posting from last month where he indicates his next steps and what he's filing. As a result, we do have to preserve this evidence. There's no way to give it back to him and ensure that we have legitimate access and that it's preserved. This doesn't exist here, though that exists in statute as an option. Further, the whole question here under this provision of the statute for return of property, we're not talking about any of the sections that are dealing with an illegal seizure because everything was legal. It was all legally seized. When we look to those two fraudulent passports, we're seeing that those are two items that have been used in the courts of his criminal conduct. So having law enforcement retain possession of those is reasonable. That's it. That's the bottom line. It's a reasonable, under the reasonable analysis for this statute, that's the bottom line. Despite Mr. Blandino's laughter here, he's not the one that decides what's reasonable. We know what he's going to do when he gets those items back in his possession, exactly what he's done with them for the last 20 years, right? If you would recall, some of the evidence for those two fraudulent passports is that he was using them in the 1990s and had certified documents from the Boulder City Municipal Court that he'd actually used those, provided those to a city attorney, and had them fraudulently accepted as a driver's license. And then later on in the 2020s, is pulled over and using those again with law enforcement on scene of a stop.
But I mean, the desktop and stuff, what?
No, those are the passports, Your Honor.
Right, and I understand the opposition to that, but the computers, I guess I'm having a harder time. Is there evidence on them?
I apologize. I didn't want to cut off Mr. Dickerson. First of all, that opposition was filed yesterday at 1:00. That is too late under the rules of this court. So I would ask you to strike that firstly and strike everything that Mr. Dickerson just said because it's not proper. That's number one. Number two, we keep talking about these passports. He was charged and the state dropped all charges against him regarding those passports. So to hold on to them when they themselves denied their ability to prosecute him, that doesn't, honestly, and it doesn't pass the smell test.
We're still within the statute of limitations, I believe.
But, okay, so go and
And we also did use them as evidence. In the case, we did not drop all charges.
What? Of course you did.
Do
I'm
you
sorry.
want an opportunity to reply? I mean, I've read the state's opposition. If you want an opportunity to reply, I would give you that opportunity.
I mean, Your Honor, I honestly, like I said, he should get his property back. If you're really, mulling this over, yes, I would like an opportunity to reply. Not that I want to drag this out any longer than it's already been, but
I'm just concerned, what is on these computers and hard drive that would become, if we did attack the conviction, that would ever become relevant?
So
I mean, I just can't.
part of
This is so incredibly stupid. It's nice to see Kim is still kicking. It is. I've had several conversations with Kim. He's a nice guy. He is a pain because this is his entertainment in life, but this is incredibly stupid. He tried to pass these things off. He got away with it because the prosecution, in their discretion, decided it wasn't worth their time to pursue, not because it's not a problem. And then he asks for it before his probation is terminated. The guy just wants to be on probation or in jail. It's that simple.
If you recall in the case that he'd been preparing documents and sending documents over as part of his extortion scheme. So his computers were used to do that.
All right, but the documents, you had the actual copies of them and they were introduced into evidence, right?
Right. And then the forensic analysis of the computers goes deeper to show how they're prepared.
So why would the state still need the computers?
As there evidence in the case.
Stop.
Were they, I mean, they weren't introduced. I mean, the documents were, but not the actual computers, right? I mean, I know there
believe
were
that's-
photos.
I don't recall if we introduced some sort of forensic analysis of the computers or not. I don't recall as I stand here today.
Yeah, I do not believe the computers were introduced, Your Honor. And again, Mr. Blandino is actually really concerned about his novelty passports. And the issue being, as we said, state dropped all charges. What he wants to do is take those passports and properly give them to Mr. Marco Rubio at the State Department to try and get actual approval for them this time. So he wants to do it the right way this
He doesn't
time.
need these to do it the right way.
I'm sorry, Your Honor?
He doesn't need these to do it the right way.
Again, Your Honor,
Right.
as well, some of us may be on different planes here, Your Honor. As you recall, Mr. Blandino believes he is a citizen of the Kingdom of Israel and that his home is the
I don't even know how Marco Rubio gets involved in this. I don't even know what the hell he's on about.
embassy or something, consulate, sorry, of that country. And he wants to get recognition from the United States government, particularly Mr. Rubio, for those. And again, I just go back to they weren't evidence. And they were
Not in this case, but in the case where he was charged.
Recognition from Marco Rubio. What the hell good is that going to do you? What good is that going to do you? He just wants legal trouble. That's all there is to it.
Your Honor, I mean, they're not.
Tell me they weren't admitted into evidence.
Well, he's indicating
Tell
that
me that we
it's
didn't
still
litigate
within
all
the
this that you're
statute of
talking about right now.
limitations as well.
When you drop the charges. If you
I suppose. I highly doubt Marco Rubio's going to take time out of his day to consider Kim's request. And he also doesn't have authority to do such thing. He can't just unilaterally recognize him as something else because he holds an office.
drop the charges.
Convicted of two misdemeanors.
Yeah, and the passports were felonious, according to Mr. Dickerson. He dropped the charges. If you drop the charges, what's the basis on being able to hold that evidence? They dropped them. And he's completed everything.
Okay, based on this argument right here, I mean, there's no reason why they can't just bring the charges now. They really should, just to make everybody happy. Okay, fine. I will prosecute your client for it then. That's what he clearly wants. That's what you're begging for as his counsel. Let's do it.
About the way that those items were evidence in that case. It's just a clear misrepresentation.
Say that again?
It's a clear
Well,
misrepresentation
what'd you say before that?
that those items were evidence in the other case.
Okay, because I thought they were, I
And
mean,
all
I
of this
saw copies
conversation
of them.
here about the argument about the Kingdom of Israel, which hasn't existed for about 900 years, all of that, it means nothing.
Well,
Because this all comes from arguments that were made in the justice court trial that went to whether the defendant had some exception or whether he was a citizen or a resident of Nevada or a citizen of the United States, whether he renounced his U.S. citizenship. All of that was at issue in that case. And those passports were part of that.
Okay,
But again, Your Honor, their novelty, the state dropped the charges. I still haven't heard any reason why the state should retain them. I mean, nothing. I have heard nothing. They were not charging him. They didn't charge him. And he's done everything he's asked of this court. You yourself gave him an honorable discharge.
What's
I don't
funny,
even
Your
think
Honor-
I have jurisdiction over those issues because that case wasn't in front of me. My concern is the computers. I mean, I haven't really heard anything for the state to hang on to the computers, 1 through 4. I mean, I'd be
Your Honor,
inclined to,
if that's where we are, I would ask you to, interlineate or cross out, with our permission, the passports. I will file a motion in Justice Court 2 to try and get those back.
you sent the order over?
We did, Your Honor.
Okay.
We sent it to the inbox, but I may have another copy.
Yeah, but I don't, when you send it to the inbox, I can't, alter it. I don't know, maybe Pam can. But, I mean, I'd be inclined to grant as to 1 through 4, the computers.
I will resend that, Your Honor.
Okay.
What I will do is however,
Grant as to 1 through 4 and, deny 5 through 7. Because I don't know what miscellaneous legal documents are. I assuming those were in the vehicle. And so I think you'd have to be more specific.
I have a copy of that. Okay, and I apologize, Your Honor. You're granting 1 through 4.
Right. I don't know what miscellaneous legal documents are. I assume it was paperwork in the vehicle.
Yes, Your Honor.
But if that's not the case, I just think you need to be more specific.
Thank you, Your Honor. So should I edit that order and resend it over?
Yeah, 1 through 4 is granted.
Great. Thank you, Your Honor.
You bet.
Much appreciated.
All right, I got one here from Alyssa. It looks kind of fun. Let's do it, shall we?
Next we'll see Rodney Terry, I guess.
Rodney.
Rodney. All right, come on up.
Yes, ma'am.
All right, on the record in City of Lansing versus Rodney Terry, 2500492 OM and 2500743 OM.
Assistant Public Defender Jacob Riley appearing on behalf of Mr. Terry for the purpose of this arraignment.
And you, sir, you are Rodney Terry?
Yes, sir.
All right, Mr. Terry, what I've got is 2 files here. I'm going to read them both to you. The first one says on this ticket, that on or about March 12, 2025 at 3:07 a.m. that you were on South Pennsylvania Avenue near East Miller Road in the city of Lansing, and that you were trespassing on the property of another. That is a violation of city ordinance punishable by up to 90 days in jail and or $500 in fines. The other ticket says that on February 15, 2025 at 10:19 p.m., you were at a location of 6200 South Pennsylvania Avenue on South Cedar Street, and that you were trespassing at the Meyer store on the property of another. Again, that's a violation of city ordinance punishable by up to 90 days in jail and or $500 in fines plus court costs. Do you understand these charges and possible penalties?
Yes, I do.
You have the right to have an attorney. If you can't afford one, we'll see if the public defender will represent you. You have the right to a trial that could be by jury. You have the right to see, hear, and question all of the witnesses against you at trial. You have the right to bring witnesses in your own defense, and you can get a subpoena to make them appear. You have the right to testify at your trial if you wanted to, but if you did not want to testify, the city attorney could not use your silence against you. You have the right to be presumed innocent unless the government can prove that you are guilty beyond a reasonable doubt. Do you understand these rights so far, sir?
Yes, sir.
Are you requesting a public defender to assist you?
Yes, sir.
Okay, I'll put that down. So we'll set you for a pretrial in each of these cases. Your pretrial is scheduled for March 25th at 11. March 25th at 11, and that's with Judge Simmons. It looks like you've got cases with Judge Simmons right now.
I do.
Yeah, okay. It looks like you already have Ms. Sutter on your other cases too. Just looking
Yeah,
to
I
see.
have
if
an
you've got
appointment
cases.
with my CMH worker today. I haven't had my injection in over a month or two, so I kind of
Okay.
messed it on.
Okay, so you haven't had your injection in a month or two, which means you didn't just
I
miss it
haven't had
today.
it. I haven't had it. I need it today.
Right, right. And I'm saying you've been missing it for a while then, huh?
Wouldn't say I've
Not
been
quite
missing it.
that long, but I don't normally be
Okay.
missing it.
Well, maybe I can get CMH to come get you and take you to get your injection. What do you think?
What do you mean? What I'm asking for is like some type of, if I could perhaps maybe get out today.
Some jail?
No, if I can perhaps get out today, Your Honor.
Okay, well, I want to see if CMH can come get you to take your, take you to get your injection.
Okay.
I'm gonna try and email them and see that if they can do that for you, since you said you haven't had it in a while and you're not feeling that great. Okay. So, Mr. Terry, I just want to make sure, have you been making it to your court dates lately?
I have, Your Honor.
Okay. Tell
I
me,
promise I will.
all right, the address they've got on some of your other files is this Jolly Road address. Is that a good address for you?
Yes, Your Honor.
Is that someone like a payee or something?
No, that's my worker.
Oh, okay. I see. So they send the mail to your worker and then the worker makes sure you know about court?
Yes, Your Honor.
I see. Do you have a phone number that you use?
Yes, Your Honor.
What's that?
346-8409.
Is that you or does that get to your caseworker?
That's my caseworker.
So how does your caseworker tell you if they get a court notice for you?
Well, I go check my mail, of course.
Okay, you do check your mail regularly? Okay.
The request was a PR bond.
I know, I'm trying to email the CMH right now about your shot.
No, you don't have to email them. All I would request was a PR bond so that I can be able to go to my appointment with my worker.
Well, that's what you say, but you also said you haven't had it in a couple months, so I'm concerned that you won't get there and get your shot.
Last month, Your Honor, last month.
Okay. Okay, well, I'll think about that. Okay. Mr. Riley, anything else for bond?
Just to note that, of course, this is a trespass charge, not violent, not threatening. I don't believe that Mr. Terry is a dangerous individual, Your Honor.
Yeah, Mr. Terry has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 open cases with the court right now.
Yes,
So,
Your Honor. I do go to court, Your Honor.
I just want to make sure that you're receiving your treatment because I'm concerned about the number of open files you have at this time.
I promise you, I will.
1 second here. I just want to see. All right. Everything is trespassing or retail fraud. Okay. For now, the order of the court is that bond in each file is $25 cash surety with a PR to CMH or in 2 days. Conditions of your release. Okay. Conditions of your release: don't leave the state, show up for court, don't commit crimes, and attend your appointments at CMH, okay?
Yes,
Okay, so my goal is to see if CMH will come get you. If they won't come get you, then I'll let you out, but I want to see if they'll come get you first, okay?
don't come and get me. Just if you allow me, just at least I can catch the bus. I'll be able to go to my appointment right now.
All right, Mr. Terry. Mr. Raleigh, anything else for Mr. Terry today?
No, Your Honor.
All right. Don't forget about your court dates. It looks like you have 2 back-to-back, March 24 and March 25th, because you have a lot of cases. Some are with the city, some are with the state. So don't forget, March 24th and March 25th, you need to be here with us.
Okay, Yarn. So do I get out
Technically,
today?
Judge Simmons. Well, it depends. It depends. The way I wrote it is I want them to at least hold you for a little while to see if CMH will come get you.
Why do you have to hold me when there's a bus right here and I have bus fare to go to my appointment?
Well, Mr. Terry, I guess because I'd rather feel like they're coming to get you and I know for sure that you're going. That's why.
I am. I need to catch the bus there though, because there's a bus right out front and I have money in my property. I can get on the bus.
Mr. Terry, I made my ruling for now. I'll revisit it later if CMH says no.
So if they say no, what's gonna happen then?
Then I'll convert it to a PR bond if they won't come get you.
Okay.
Okay.
So is it already, am I already bonded? So it's still a bond, isn't it?
It's a temporary bond to see if CMH is gonna come get you.
Okay.
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 You're all set, sir. Don't forget, 24th and 25th.
24th, 25th, sir.
Okay, Jacob Larson.
Excuse me, Your Honor.
Yeah.
Be a tablet at the hospital. The sergeant is headed there with a tablet.
Okay. I guess we'll get there when we get to it. Nobody's logged in yet. Do you have Jacob Larson?
All right. Does anybody have a good call for me? We're time filling, waiting for a verdict.
Okay. On the record in City of Lansing versus Jacob Larson, 2403621OM and 2403645OM.
Assistant Public Defender Jacob.
Mr. Detective, your name first. You're muted. There you go.
Yo.
Your name, Detective?
Detective Serna, Woodhaven Police Department, Your Honor.
Mr. Bogas, come on up here. Closer. Tell me your name. Right there is good.
Zachary Bogats. Good morning, Your Honor.
So he's either going to plead guilty or we're going to have a hearing as to whether or not he violated the no contact provision. The file reflects that yesterday, Judge Kirsten set a no contact provision with regard to a Brittany Childers. I took testimony from Detective Serna indicating he violated that last night by making the call to the victim from the jail sometime around 7 p.m. So how's he going to proceed?
Your Honor, my client's going to plead guilty.
If you plead guilty here, your release could be revoked, bond forfeited, and new bond set. Do you understand that?
Yes, sir.
You have the right to a hearing as to whether or not you violated the bond. You can remain silent. You can testify if you so choose. If you remain silent, I won't hold that against you. If you want to have a hearing, I'll give you one. You can bring in your own witnesses, use the subpoena powers of the court to bring in those witnesses, testify or remain silent. And then the people have to prove by a preponderance of the evidence that you violated the no contact provision. Do you understand that?
Yes, sir.
If you plead guilty, we're not going to have a hearing. Do you understand that?
Yeah. I'm
Yes?
only pleading guilty to violating for the call, right?
That the charge is that you violated the no contact provision, whether by call, text, or otherwise. So yes, that would be, that's what they're claiming is that you called.
Okay, yeah, I'm pleading guilty for that, yeah. I'm not pleading guilty for all my charges, though, is what I'm trying to say.
Of course not. Of course not. I don't even want you to talk about the charges.
So,
Is that
yeah,
what you
I
want to
plead
do?
guilty for the, yeah, I
To
plead
the
guilty
charge
for the
you
call, yeah.
To the charge you violated the no contact provision, how do you plead?
You gotta take that phone out of here, whoever's phone's paying out.
Get it out of the courtroom, out of the courtroom. Folks, I want the phones out of the courtroom. If you can't keep them off and silenced. I want whoever's phone went off, you're gonna have to leave the courtroom. Whoever had the phone, leave the courtroom.
Whose phone went off?
Take the phone out of the courtroom. Get it out of here.
I don't have a phone.
Who has the phone?
That way. I heard it come from that way.
Who has the phone?
This gentleman
I'm on this side, I can hear it that way. I got ears.
Okay, good enough. Shh, good enough. All right, to violation of a no contact provision, how do you plead?
Guilty.
Did you make a call to the victim yesterday, March the 12th at roughly 7 p.m. from the Woodhaven jail?
Yes,
Did Judge Kirsten order you not to have contact with the victim yesterday when you were being arraigned in court?
yes,
I'm sorry, I didn't hear.
yes,
Anybody force you to plead guilty?
no,
I'll accept the plea. Please accept it. I'm going to listen to anything you have to say, counsel.
There's nothing to add, Your Honor.
Why are you violating judge's orders?
I ain't really got no one else to call, Your Honor.
Bond is raised to 50,000, 10%, same bond conditions. I want to be clear. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No contact with Brittany Childers. No contact with prosecution. Witnesses, you're not to enter the property. Address at 25227 Oxford Street in Woodhaven. You're not to possess firearms. You're not to possess dangerous weapons. You're not to be within 2 miles of the victim, her residence or place of employment. It looks like he ordered a GPS tether, correct, Lisa?
Yes, that's correct.
And that he was not to be released until fitted with that tether. Is that true?
Correct.
So I'm going to make it clear on here to the extent it isn't, and I'm going to have you just up the bond to 50,000, 10%, not to be released until fitted with a GPS tether either, sir. So you're going to have to post the bond and then they'll fit you with a tether and you'll be released. Listen, you're not going to do yourself any favors if you violate judge's orders. Do you understand what I'm telling you?
Yes, sir.
If this happens again, I'm going to really raise it and you're not going to be able to, I can promise you, you're not going to be able to post that. Do you understand that?
Yes, sir.
Good luck.
Thank you, Your Honor.
Diamond Mercedes.
Thank you, Your Honor.
22B 141007. Ma'am, your name?
Diamond G.
You charged, you have two prior technical violations, and in this one, I have 4 different counts. Count 1 alleges you failed to attend the victim's impact panel. Count 2, you failed to pay fines and costs as ordered, the balance owing $1,200. Count 3, you failed to clear all your warrants. Count 4, that you failed to attend outpatient treatment as recommended. If you plead guilty, if you're found guilty, that would be 4 more. Your probation could be revoked. You could be incarcerated for the maximum on this case, which is 93 days. Do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights?
Mhm.
Yes?
Yeah.
If you plead guilty at any time, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Okay.
Do you understand that?
Yes.
Now, you have the right to a lawyer. I think you should get one. I'll give you one at public expense if you want one. You want a lawyer?
Yeah.
Okay, so I'm going to indicate that you want an attorney. Entering a not guilty plea. We're going to have a revocation hearing. We're going to set you up with a lawyer, and then you'll come down back here and you'll be in front of me with your lawyer. So you can go right out in the hallway. Any questions?
No.
All right, good luck. People against Amberlynn Mattis, 240-147-557B. Come on up, Ms. Mattis.
Mike Baldwin, House Counsel P 65417. Again, good morning, Your Honor. I'm here for Ms. Matisse.
Ma'am, your name?
Amber Matisse. Judge, today's the day and time set for a violation of probation show cause. I have had an opportunity to counsel and advise my client. There's also a advice of rights for the preponderance of the evidence. My client is going to plead guilty to 1 count of consuming alcohol.
Is that what you want to do, ma'am?
Yes.
If you plead guilty to that, this would be your first technical violation. You could get 5 days. Do you understand that?
Yes.
Call in, Jessica, please. Did you sign, read, and understand the advice of rights form?
That yellow piece of paper?
Yes.
Yes.
Ma'am. If you plead guilty, you'll be giving up all those rights and there will not be a hearing nor a trial. Do you understand that?
Yes.
You have the right to a lawyer. You're happy with your lawyer, right?
Yes.
To the charge, failure to refrain from consuming alcohol. How do you plead?
Guilty.
Did you test positive on February 17 of 25 with DNA for alcohol?
Yes.
Did I order you not to purchase, possess, or consume alcohol?
Yes.
Anybody force you to plead guilty?
No.
Plea is accepted to that charge. I find it to be an accurate plea. Made voluntarily and understandingly, the plea is accepted. This isn't good. I just put you on probation. What happened?
Thank you, Judge. Well, what happened is she didn't prioritize her life activities and she's not thinking proactively. And for those reasons, as a young mother, she's putting herself in a very precarious situation. So, Judge, we talked about prioritization. The court's orders are paramount. Without her freedom, she will not be able to enjoy her family, work, education, and entertainment. Proactive thinking before you do something that has a consequence that can lead to jail. She's here with a female friend who's been a mentor, and she was very receptive when we spoke in the office. She's making a foolish endeavor because not only is she subjected to 5 days, she's got 7411 there checked on that box on that form, I believe. And
yeah, the conviction could enter too.
Yeah, yes. So I'm hoping that the few minutes that we spoke in the office have sunk into her mind that she needs to be strict adherence to the court order, take care of her health, and make sure she prioritizes her activities and think before she acts, because actions have consequences. I'm going to ask for, because of the 7411, I'm going to ask for 3 days on the court work program as a jail alternative, realizing that Your Honor could pull that 7411 realistically as a punitive measure and allow her to stay on probation. So.
Just put on behalf of probation.
How's she doing
Well,
otherwise?
she's just been placed on probation.
I know.
I really don't have proof of anything. I actually had an appointment scheduled with her tomorrow. So tomorrow was the day I was gonna go over everything with her. I don't have any proof of her getting any treatment or anything yet. She still has time to do her community service hours. So again, there really hasn't been time for her.
Where did you drink at?
My house,
With who?
my cousin.
Do you have alcohol in the house?
No,
Who brought the alcohol over?
my cousin
They
did.
know, is it a boy or girl, man or
A
woman?
girl.
Does she know you're on probation?
No, she didn't. I don't know.
We talked about restructuring our lives around sobriety.
Let me see the screening report. Where do you work at again, Miss Mandis?
I just started a job at IHOP.
Okay.
I serve
And she has children.
How many children?
5.
You have 5 children?
Yeah, 9, 8, 7.
Yeah,
5,
9,
and
7, 5, and 2.
1. But she's 1. She's not 2.
Are you collecting child support?
I'm supposed to get it, but I don't get it.
Why not? Go after him.
Well, their dad.
Is it the
he
same
pays the
father?
bills and stuff. He just came back home so he could watch the kids while I work because
Is he, hang on,
This is the situation, Judge, where she has the father in the life who's independently stepping up, transporting her where she needs to go, paying bills and going to work. So that he's being very mature.
No, and I found a job so I could pay my fines and stuff and also take care of my kids.
So he's picked up the second job.
all right, look,
He's laid off. Because he does construction.
Oh, yes.
listen, you don't want this conviction on your record, okay?
Okay,
All right?
I appreciate it.
Well, I didn't say I wasn't gonna do that. I'm just
No.
telling you, you don't want it on your record.
No, I apologize for not listening.
All right, I'm not gonna do that, though. Listen, I'll give you another chance.
Thank you.
Fritz, please. I'll go light on the costs. I'm sure you don't have a lot of money. You collected $860 on a bridge card.
Yeah,
Cost of 50, serve 10 hours community service. I won't revoke the status. I'm gonna give you these 10 to be completed. When are the others due again? Can you
The
tell me?
others are due April 1st, Your Honor.
To be completed by May the 1st, okay? So I'll give you some time. All right? Can you pay the 50 today or not?
the 50 that I owe tomorrow.
I'm just gonna say, pay this 50 on these by May 1, 2. So the $50 on this has to be paid by May 1, September 10th. I'm sorry. May the 1st, you have to do 10 hours of community service additional by then, all right?
Your Honor, do you want her to go to the probation department today?
Yes, yes. Okay? And you have Barton too, right? Kelly Lynn Barton,
Yes, Judge.
23 out of 5 on 3503.
Yeah.
I'm gonna go grab her file.
Fine. Ms. Barton, your name?
Kelly Barton.
House Counsel Attorney Mike Baldwin from this Barton. Judge, today is the day and time set for a show cause on violation of probation. I have had an opportunity to counsel advise my client who has signed the advice of rights on the ponderance of the evidence standard. She will be pleading guilty to 1 count of violation of probation for use of alcohol.
So do you understand this would be your 6th technical violation, correct? And you could get,
You have 5 prior.
you could get 93 days with credit for any time you've already served by way of court work or community service or jail or otherwise. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
To the charge that you failed to refrain from consuming alcohol, how do you plead?
Guilty.
Did you test positive for alcohol at a chemical test on this February the 14th of 25 at DNA?
Yes, Your Honor.
Did you consume alcohol within the 2 or 3 days preceding that test?
Yes, Your Honor.
And I ordered you not to consume alcohol, correct?
Yes.
Anybody forced you to plead guilty?
No, sir.
I don't know what, okay, I'm gonna accept your guilty plea. I don't know what I'm gonna do with you anymore. How many of these have we had? Your name?
That's going on arbitration.
I don't even want to look. It's just been going on and going on and going on. I don't think I gave you 3 days back on your 4th violation. Then I was nice on the 5th violation. Now here we are on the 6th violation.
All right. We've got another one from Alyssa here. I'm told there's a Karen involved. It might be Christy. I'm not sure.
Hello.
Hello. Yes. Hello.
Hi, my name is Kirsty Knight.
Hi, I'm Michael Always.
We're starting strong.
Yeah, I'm here. I had a 9:01 appointment. This is my second time. The last time I waited a whole day and they didn't see me. So they.
Good morning. If you can see and hear these
Oh, it's
proceedings,
her.
could you please give the court a thumbs up?
Yes, I'm giving a thumbs up.
Thank you so much. Welcome to the 44th District Court. I'm Magistrate William Urick. If I'm speaking to you right now, it is the date and time for your informal hearing. An informal hearing is just that. These are civil proceedings of a non-criminal nature. Nobody will be going to jail this morning on their traffic ticket, but it is considered serious enough that the citing officer issued the ticket on the date in question, and the court is joined this morning by Sergeant Smith of the Berkeley Department of Public Safety. As the party requesting this hearing, you will be required to make a selection from one of three options to protect your rights. You may, if you wish, simply admit responsibility to the citation. The court will attach the scheduled fine, and that will close your case. You may also, if you wish, admit responsibility, but with an explanation that you believe mitigates your circumstances. Your third option is to deny responsibility. That is your right and your privilege if you do so. We will conduct a brief trial. The court will swear both parties under oath. The officer will testify first. They have the burden of proof. Then it will be your turn to testify, provide your evidence to the court, and then the court will be required to make a finding of responsible or not responsible. And that is based upon the civil burden of proof, which is a mere preponderance of the evidence. So this is not criminal court, and it does not require a steep burden of guilt beyond a reasonable doubt. The people can prevail on their case if they simply make a 50.1% quantified standard, or if they do not make that standard, the case could be dismissed. So with that said, the court will excuse you back to the waiting room and we'll undertake the matters one at a time. Please have your selection ready when it is your turn. Thank you. Court calls case numbers 24 B like Berkeley E 04807 and 807A. These are people of the city of Royal Oak versus Kirsty Lynette Knight. That's you?
Yes, sir, that's me.
Thank you, Ms. Knight. You were present just seconds ago when the court explained the nature of an informal hearing. Is that true?
I'm already.
Yes, sir, I was here. Yes.
Thank you. So you understood the court instruct that you must select from one of three options to protect your rights, correct?
Totally. Yes.
Thank you, Ms. Knight. The citation before the court was issued on November the 27th of last year at about 20 minutes of 9 in the morning. You were operating a 2019 Mercedes black in color northbound Greenfield Road at a 12-mile road in the city of Berkeley. And at that place and time, you committed the civil infraction of improper lane use, and you apparently had your bright lights illuminated without bringing them back down to the normal level. Officer, strike that. Sergeant Smith's citation and remarks indicate went straight from left turn lane, and it is suggested that he observed this from southbound at intersection. So you have your three options, Ms. Knight. You may admit responsibility. You can admit and explain, or you can deny responsibility and we will swear the parties and take testimony. What would you like the court to do?
I would like the third one, deny. Because I don't feel that because.
I'm sorry, you're good. We're keeping a record here. Do you both solemnly swear the testimony you shall give to this court will be the truth, so help you God?
Yes, I do.
Thank you very much. Sergeant has the burden of proof. Then it's your turn. Miss Knight, please stand by. Sergeant, proceed. You'll need to unmute first.
Sorry about that, Your Honor. On November 27th of 2024, at approximately 8:37, I was southbound on Greenfield, just north of 12 Mile, when I noticed a black Mercedes-Benz traveling northbound in the left turn lane to go west on the 12 Mile in the Southfield. That vehicle passed other vehicles that were continuing to go north on Greenfield just before 12 Mile. And then I saw the vehicle change lanes back over into the straight through lane to continue straight down Greenfield, going northbound, crossing 12 Mile. The vehicle also had its high beams illuminated at the time when I saw it. I turned around and stopped the vehicle just north of 12 Mile on Edwards in Southfield. Issued a citation to Miss Knight for improper lane use and also for driving with her bright lights
on. And is there anything further you wish the court to know that developed with respect to the traffic stop itself?
No, Your Honor. Other than, like I said, there was other traffic around, so Miss Knight should have just made the left-hand turn from the lane that she was in versus trying to get back over after passing other vehicles to continue straight.
And obviously this is late fall, plus or minus Thanksgiving, so it was dark.
It was still daylight, but the bright lights were definitely.
Oh, I'm sorry. It's AM, not PM.
Yes,
and the bright lights were on.
Bright lights were on.
Thank you. My apologies.
Yep.
Are you able to determine based on your training and experience, because some of the new headlamps are blazing? Were you able to determine if it was by your observation, the actual bright lights engaged?
Definitely the bright lights were engaged, Your Honor. Noticed several different lights, different vehicles, and I know some are bright, but this was extremely bright and glaring.
Very well.
And also, Your Honor, I just wanted to add, no, I think that was it, Your Honor.
All right. You obviously have the right to rebuttal if you choose to use it. And Miss Knight, it is your turn. What would you like the court to know?
I want the court to know that just because you're an officer and you're having a terrible morning is not a reason for you to harass someone and give them a ticket.
Miss Knight, this is not the time to make complaints about the officer. This is your day in court. You have 2 civil infractions that you've been cited for.
Oh, yeah.
So the purpose of this hearing by law and rules of evidence is you have denied responsibility. So now would be the time to make a presentation relative to why you feel you are legally not responsible for the citations. Any disagreements you have with personality or otherwise are not appropriate in this forum. Today is concerned only with the bright lights and improper lane usage citations. So please continue. Thank you.
I was heading on Greenfield. I was heading northbound. I was turning in the left lane. There were no passengers coming up the lane. So I put on my turn signal and I made an educated guess because there was nobody coming. I looked, I turned on my signals and I proceeded to the left lane. In terms of my lights being on, I have a doctorate degree. I am not stupid by any means, and I did not have my lights on, and I had a passenger in my vehicle with me who witnessed everything and saw that I was harassed afterwards.
Okay.
By this officer.
So your suggestion is you made proper use of the left turn lane by making a left turn.
Yes, sir. I looked, I made an educated guess. There was no cars in that lane. Before I proceeded to turn to the next lane, there was nobody coming. I made the right decision by putting on my traffic signal and went to the lane, and I went through the light. So I had no understanding of why I was stopped and harassed.
Okay, the court is having some difficulty. I want the record to be 300% clear, okay? So your suggestion is you simply made a normal left turn from the left turn lane onto 12 Mile Road from Greenfield. Is that your testimony?
No, my testimony is that I was going to make a left turn. I looked, I saw that the light was changing and there were no cars coming. So I put on my right turn signal and looked before I did anything and proceeded through 12 Mile heading northbound. I had no understanding of why I was being stopped. Like I said, I knew that my lights were not on. And why would my lights be on at 9 a.m.? I know how to work my vehicle. I have had it for some years now. So there was no misunderstanding there. Even if I had another person in the vehicle with me who told me that, yeah, they witnessed that I was harassed and there was no reason for me to be stopped. So that is the reason why I went to the Royal Oak Court to pursue this. If I am wrong in something, I don't mind taking responsibility. I am a law-abiding citizen. I am a certified teacher and administrator. I teach children how to follow the law and how to be obedient so that they can be successful in their lives. So why would I break? I don't break rules. I wasn't even raised or trained this way. So that's not what I do. So I had a serious problem. And then the way that he came to my vehicle and harassed me and talked to me like I was less than an individual because I had my mother's driver's license in my wallet, in which was none of his business. I just had recently lost my mom. My mom was handicapped. She lived with me and I cared for her and my grandma. So while looking for my license, he probably saw my mom's and my grandma's license. And I was harassed over that, which was none of his business, what I have in my wallet. And I was harassed.
All right. Is there anything else you want the court to know other than what you've already presented, Ms. Knight?
I wasn't in a rush because my home, I live right off 12 Mile. I live in between 12 and 13, but I'm closer to 12 now, right off Greenfield. So I wasn't in a rush. It was, like I said, it was early morning. I'm the type of person, if I did something wrong, I will pay my ticket and go. But in this instance, I did nothing wrong. I made an educated guess. I looked, I turned on my signal. So there was no need for this. And so that's why, I'm standing up for myself because, it just wasn't right. It wasn't fair. And, that's how I feel.
Okay. So I believe the court understands what you're trying to suggest, and that is that you went to the left lane. Then you changed your mind. You looked behind you. You did not see any traffic that you were aware of. You turned on your right signal and then proceeded through the intersection.
Correct.
The court heard you just say that you were on 12 Mile Road. Was it a situation where you realized you forgot something and you therefore wanted to go north of 12 Mile on Greenfield?
Not at all. I was heading north on Greenfield. I was actually on Greenfield. The left lane was a turning lane, which was for 12 Mile.
So you had just suggested you live right by there. So you were not going home.
I was going home, but I took
Then why did you go straight through rather than turn left if you live on 12 Mile?
Because I was heading to the coffee shop right there.
Okay,
but
so
I
you
was
weren't
not
going
in a
straight.
rush.
You weren't going straight home.
Right.
Okay, thank you.
Correct.
Is there anything further you want the court to know?
Pretty much that's it. That's where I stand. I have nothing further to say, Your Honor.
Okay, thank you so much for your presentation. Rebuttal testimony, please.
I have nothing, Your Honor, other than there was a video saved for this incident. However, because of the timeframe, it's been purged from our system.
Very well. The court has heard the testimony of both parties in the matter of Berkeley versus Kirsty Lynette Knight. The court noted at the beginning of this traffic docket that the burden of proof in a civil matter is a mere preponderance of the evidence, quantified at 50.1%. Related to the bright lights and given the time of day, the court does not believe that the evidence has reached that level. So in that regard, the court finds Ms. Knight not responsible with respect to the improper lane usage, regardless of whether or not we make a unilateral decision that what we're doing is safe. There was a violation of the motor vehicle code and the burden of proof was carried as to that. So the court is finding Ms. Knight responsible for that particular citation. The attendant fine for that citation is $130. That is payable through the pay portal on the court's website, or Ms. Knight can walk a cash check or charge into this court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That is going to be due within 7 days. Ms. Knight, if you wish to appeal this court's ruling, you may do so by posting a cash bond of $130 within 7. Matter is placed upon the formal hearing docket of the chief judge, and the city of Berkeley would be represented by City Prosecutor Dan Chris. So either a bond or a fine of $130 within 7. That completes your hearing. Thank you.
Thank you.
Hi, this is Attorney Mike.
Okay. I agree with you that, and here's what I am because, listen. This is a citation. It was issued on February 15th of this year on 142nd Avenue there in Door Township. Improper lane use.
This is also
Mr. Meyer, you're here on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility. Excuse me?
Am I allowed to talk to the officer privately or no?
Well, we would have done that before today. This is the informal hearing. Or two, you can admit responsibility and provide some sort of explanation as to how or why this happened. Or three, you could contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I'm contesting it. I'm fighting it.
All right. Then the first thing I'm going to do is have you both raise your right hands. Do you swear or affirm any testimony that you give here today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor. Yes, I do.
All right. Mr. Meyer, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place. But then after that, you'll have an opportunity to either ask questions or testify in your own behalf. All right. And with that, deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Yes, February 15th, approximately 2:47 in the afternoon. I was on routine patrol in Door Township on 142nd Avenue, traveling westbound. Just to give you a little bit of update on the surrounding area. Eastbound and westbound, single lane with a left turn lane in the median. I observed a Honda sedan traveling eastbound on 142nd, traveling behind three vehicles. The front vehicle was making a right turn, and the two vehicles behind the vehicle making the right turn came to a stop in the roadway. The gray Honda sedan began to make a pass in the left turn lane, passing three vehicles at once and getting back into the eastbound lane after moving out of the left turn lane. I initiated a traffic stop due to the hazardous pass and advised on the issue. Subject admitted the pass as he drives for a living, and he drives for, I think it was Uber or one of those eating apps. And he was on his way for a delivery and didn't understand the hazard of the pass. So I ended up giving the warning for the improper pass and issued a citation for the improper lane use.
All right. And Mr. Meyer, what is it you wish to tell me?
I was doing DoorDash. I had just delivered into that area. It was a lot more safe to do what I did. I was driving behind them for a mile. So, and like he said, they were stopped on the road. I've driven for a living for a long time. I put, anywhere from 60 to 80,000 miles on my car. There was a car behind me. The only 3 accidents I've gotten in is somebody has rear-ended me. So I see people passing all the time. There was nobody. I mean, he also said he saw this stuff. He didn't see this stuff. There was nobody coming on oncoming traffic. So that's the reason why I got in the middle lane. That area does not have turn lanes. So I was driving behind this car for a long time. The speed limit's 45 there. They were going 25. So like I would agree to a ticket, but I'm not agreeing to a ticket that puts 2 points on my record. I drive for a living. People use that lane all the time to pass. You can say whatever.
Mr. Meyer, you did 2 things wrong. That's an improper pass and it's unlawful lane use.
No, it's
if
not.
you'd like
People
one
do
of
that
those
all the
tickets
time.
more than the other one, I'll allow it to be amended to it. But you're definitely responsible for one, if not both, of
No,
those
it's not.
moving
They were
violations.
stopped on the road, like the guy said.
It doesn't matter, sir. The lane use is improper, and it was an improper pass as well, because you went into.
No, they were stopped on the road.
We're all set, sir. So I would find you responsible on this citation as it's written. Now, you do have a right, because you had a contested hearing, to say, hey, I don't agree with that. I want to go to what's called formal hearing in front of the district court judges with the prosecutor's office. To do that, you must do 2 things. One is you must ask for that within 7 days of today's date. Your window of opportunity on this closes after 7 days. And 2, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights?
Yes.
All right. And the deputy, you would certainly have the option to go ahead and write an additional citation if you thought it was merited. So we're all set for today, gentlemen.
Appreciate it.
Release you.
And I did pay my bond, and I just want to get this done and so I can move on with my life. I'm sorry I absconded for so long. I truly am.
Your Honor, if I may. She's using legal terms and everything, absconded. I love it. All right, to the charge of loitering, how do you plead, responsible or not responsible?
Responsible.
Young lady, judges don't like this. Find me a judge that likes when people don't show up for 8 years.
Sorry.
$200. Good luck.
Thank you, Your Honor. Have a great
Have a
day.
good day.
Good to see
You
you.
too. Thank you very much. Take care. All right. Napoleon Robinson. Napoleon Chevalier Robinson, 24B145-730. Oh, no.
Hi, good morning, Judge.
All right, you're charged with violating a law, being convicted of operating while visibly impaired. This was taken under section 771.1. You plead guilty to the charge that you were convicted of another crime while on probation. Your 771 status could be revoked, the conviction entered, subject to a 90-day jail term. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
You have the right to a lawyer and you need one. I'm gonna give you one, okay? I'm
Yes, sir.
entering a not guilty plea for you. We are going to have a revocation hearing today. I'm going to give you this. Your lawyer this file, and you speak with the lawyer, and then you're coming back in front of me, okay?
Yes, sir.
Any questions?
No, sir.
All right, best of luck. Counsel, which one do you have?
I have a Donnelly, Your Honor.
Okay, that's Judge Hessen's, right?
Yes.
Okay. Do we have that? Give me 1 second.
Yes, sir.
I put up the time class so he can show you.
Okay, let me just, Colleen Margaret Donnelly, file number 24F 84138. Good morning, counsel, your appearance.
Good morning, Your Honor. Attorney Thomas Quartz, P77177, appearing on behalf of my client who stands to the right. Could you say your name for the record, please? Colleen Margaret Donnelly.
So we're just gonna adjourn this a couple weeks, right?
Yes, Your Honor.
When are we going to have a hearing on this, Lisa? Or Heather, whoever, I'm sorry.
Oh, 2 weeks out, we can do March 27th at 10:15.
March 27th at 10:15, okay?
Yes, Your Honor. And is it possible just to get it a little bit later in the day, or is that impossible?
No, I don't think so.
Would 10:45 work better for you?
That would be perfect. Thanks.
10:45, okay?
Thank you, Your Honor.
Have a good day. Go down the hall and get your notice. Thank you.
Thank you, Your Honor.
Take care. Jeez. Abraham Safi Sharara. 25W37628. The officer failed to appear. The defendant failed to appear. Case dismissed. Case dismissed. Sean that was scheduled, by the way, for 10, and it's now 10:30. Sean Francine McLean, 25W37781. Plaintiff is a no-show. Defendant is a no-show. This is the
Judge, Mr. McLean's on Zoom.
Oh, okay. Okay, no problem. Bring Mr. McLean in.
Yes, I'm here.
Or I'm sorry, Ms. McLean. Can you start your video, please, and state your name?
Oh, my video's not showing? Okay, I'm sorry.
No worries.
Okay, I'm not used to this.
You know what? The officer didn't show up. I'm gonna make it easy. I'm just gonna go ahead and dismiss the case. Case dismissed. You're all set.
Oh, thank you so much. Appreciate it.
You're welcome. Good luck to you.
I
Thank
appreciate
you.
it. Thank you. And I already got my insurance. Everything is good. So just what I just wanted to say. So
Well, that's good. Have a good day. Thank you.
Okay, thank you. Bye.
Michael Brandon Shenavar, 25T644710. He's not here either, right?
No, that is the only informal for us that's here, as far as I know.
Case dismissed. The officer failed to appear. The defendant failed to appear. And this was scheduled for 10:15, so both were given 15 minutes. Case dismissed. I think I would like Mr. Bologna, if you're out there, and Mr. Baldwin to come in. We'll get Ms. Stickney out of here. Well, tell them, you know what, just tell them I'm gonna take a quick 5-minute recess and then we'll be out here in about 5 minutes, okay? Tell them, ask them if they could both come in around 22. Thank you. Go off the record. And then we'll get her out of here, okay?
To go well today, Judge.
I know, you indicated that, but so far it's not.
That was my
So
intent.
I will sign off on the referral
Okay.
once it gets to me.
Okay.
You were looking for a 4-week,
Yes, Your Honor. I talked to Mr. Reyes. He needs a little extra time.
April 10th, 2025, 9 a.m. Bond continue. You have the form? Quick confessing to what Kalina hasn't done. Thank you, sir.
Thank you very much, Your Honor.
We'll be in touch, Mr. Elkins. Thank you.
Okay, thank you,
Court
ma'am.
does call the case, People versus James. Oh, I don't know. Is this black? Are they ready?
We're ready.
Are you two ready?
We are, Your Honor.
Oh.
I don't want to see it. I don't want to.
And here we go. Court calls the case, People versus James Valcourt.
Good morning, Your Honor. Marie Tanhall, Assistant Prosecuting Attorney on behalf of the people.
And good morning again, Your Honor. Christina Costantino on behalf of Mr. Becklepore. Mr. Becklepore, can you please state your name for the record?
James Becklepore.
Thank you.
Judge, may we briefly approach on this matter?
There's a pattern. Yes, you.
This guy's a
Thank
vibe.
you.
I want to see what's going on there.
Hey, young man, I'm all done. Jonas called you. Jonas called.
Court, sir.
They give you any court date?
Yeah, but
Write it down.
trial.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
I never want to hear it again. Sweet Jesus.
You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Let's go.
You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
Can you just let this go for once? For once? Once?
Okay, that being no.
I never want to hear it again.
You a whore?
Mr. Sharks.
Not a whore?
Mr. Sharks. Mr. Sharks. Mr. Sharks.
Everybody fucking dance.
You're not a whore? You're not a whore?
I never want to hear it again.
You're not a whore? You're not a whore?
I never want to hear it again.
Now, if anybody thinks this is okay, I am in the wrong.
But Simpson will tell you that being alone, we just have one question: are you a hoe? Mr. Shots, oh Mrs. Shots, oh where did you go? We have questions like on the weekends, do you work selling burritos? The long talk with my crew, we here to laugh at you. We see you in court acting all tough. Your soul says citizen life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together because wow, that was messed up. And your honor, I have IBS and I'm bleeding inside and it's really been rough. The law talk with my crew, we're here to laugh at you. We see you in court acting all tough. Your soul says citizen life must be so rough. And now Kinky Kelly is shacked up in bed with the fruit bowl. Then the cat jumped on his wiener and started causing trouble. Love exciting and new, we are and always will be. The law talk with my crew. The law talk with my crew. We see you in court acting all tough. Your soul says citizen life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together because wow, that was messed up. And your honor, I have IBS and I'm bleeding inside and it's really been rough. The law talk with my crew, here to laugh at you. We see you in court acting all tough. Judge Simpson will tell you that being alone, we just have one question: are you a hoe?
There is no schedule at Law Talk Nation. You can only pay to get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pre-trial on the dial. Planning always make your chest smile. The pro say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of Law Talk with Mike. Courtroom is always popping off. You have a failure period. Judge Simpson is never going soft. Webster is always showing heart. We are heading into that soft six summer. Did you miss the line? That's a bummer. The soft six never gets smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day our Lord would like. Courtroom is always popping off. You have a failure to appear and you scoff. Judge Simpson is never
Record
going
Troopers
soft.
actually had a bench conference in this case. There is a request to this matter, which I will grant. I'm going to adjourn it to timing wise, I'm going to go to April 17th. Probable cause conference will be adjourned at that date. The court is expecting a communication regarding bond in this case, and the court will, once received that, will take a critical look at it, and make its decision.
Very much, Judge.
Right, thank you.
Appreciate it.
Court calls the case, the People versus Thomas Ellis.
Pass it on to the people.
That's Alice.
Thomas Ellis.
Alice. Alice.
Hannah Mackey, on behalf of Mr. Ellis, who is appearing to my right, please state your name for the record.
Hold on one moment. So why did you get up at all? Because you weren't on the other case and you're not on this one. Acting really?
Yes, Your Honor.
This is
Why
her
did
case,
you
Your
get up
Honor.
at all?
I initially was going to handle Mr. Ellis's case, but I asked Hannah if she could, get some more practice.
You just didn't want to get up because you knew I was going to have something to say. Georgia, all right, go ahead, sit down. All right, go ahead, yes.
Good morning, Your Honor. We request for a 2-week adjournment, please. Your Honor.
Your name, sir? Thomas Sullivan. See, and I knew that. Nobody else did. Yeah. Grant the request for an adjournment. Probable cause conference, March 27th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, sir. Thank you for your patience. Court does call the case, People versus Michael Horn.
Pass it on to the people.
Good morning, man. Please, honorable court, Kareem Johnson on behalf of Mr. Horn.
Your name, sir?
Michael Horn.
All right, what are we doing?
Yeah, we're asking this matter be set for exam.
Discovery complete.
Yes, Your Honor.
He looks different.
People have their
than
witnesses
he
available
used
the
to.
25th.
I'm sorry, Your Honor.
Would people have their witnesses available the 25th?
We'll try, Your
Some
Honor.
weight, among other things.
Preliminary examination in person, March 25th, 2025, 9 a.m. That's before Judge Moore.
May I address bond?
You may.
Yeah, this case was reissued after a dismissal. Do not see any objective reason why the bond should be so high, $500,000. Believe there's any witness or concrete evidence that my client fired any shots, or is there any witness or concrete evidence that my client was the driver of a car in which shots were fired from? Understand that we're going to have a preliminary examination in this matter, but from all the hours of body camera footage that I was able to review, witness statements, and I know cases can be made by circumstantial evidence, Your Honor, but I don't even see it circumstantially here. And when looking at my client's youthfulness, I don't think he's a flight risk. He has family in the courtroom, his grandfather, his girlfriend, his child. I think the court can look at a lot less restrictive means, house arrest, tether, to ensure the safety of the community and that he will not flee, Your Honor. But do not think that my client is a flight risk. And without concrete evidence that he fired shots at anybody or drove a car knowing that shots were going to be fired at anybody, I don't see how he's a danger to the public, Your Honor.
When you say it was dismissed, I mean, it's a reauthorization.
Yes, Your Honor.
That's correct, Your Honor. When it was up for exam initially, the officer in charge was out of town. So the case was dismissed at defense request and we did refile it.
Got it. Okay. Response to the motion.
Your Honor, I do think the bond is appropriately set. We did put in our bond information form that this was a case involving shooting and the potential for shooting at a building. I do think that the facts in the case will be borne out, hopefully, at the preliminary examination to give all of the factual basis for this case. This shooting on Andrea Street is believed to be in retaliation for a different shooting that was related to something else where this defendant was positively identified at that prior one on Knollwood. So we are asking that the court continue the bond and keep that earliest possible preliminary examination date of March 25th.
Yeah, may I respond?
Yeah.
So it seems to be that the people's theory is that because my client's mother's house was shot up, and he was present when it was shot up, he must be responsible for this other shooting, although no witnesses put him at the scene of that shooting, Your Honor. And I don't think that
You're saying
at the second shooting. Yep. We will concede that there will be evidence that he was present at home when his mother's house was shot up. But that's it. There's no evidence that he left that location to go shoot up anybody else's house or drove anybody to go do that. And because of that, I don't think a $500,000 cash shooting bond is fair.
Anything else, Ms. Lundy?
No, Your Honor.
All right. Oh, okay, so the first shooting, when did that allegedly take place?
Approximately an hour to hour and a half earlier that night. And
we're not talking days.
It's very close in time, is my understanding, Your Honor.
Okay.
The car involved in the shooting was stopped. The second shooting. Was stopped that night by law enforcement. My client wasn't in the car.
He was not?
No, he was not.
Okay.
But it was the car was registered to him, Your Honor. That is be a fact that we will be conceding at exam and trial.
Okay. So I'm not jumping to any. The car that was involved in the second shooting belonged to the defendant.
Yes, sir.
That approximately an hour before, correct me, but sometime just shortly before that, the defendant's mother's home was shot up.
Yes, sure.
Yes.
And Counsel, you said he was present at the home when his mother's house was shot.
He arrived after the house was shot up.
Got it.
He's on body camera, but he's not on body camera leaving in the car that is caught after the second shooting, the shooting we're here for. He's not in the car.
Okay. All right, I got you. I think. All right. Well, what I'm going to do at this time is I'm going to deny the request for the bond reduction. I'm going to leave bond set where it is. We're 10 days out or whatever it is from a preliminary examination. Let all those facts come out and then let Judge Moore make a decision as to proper.
Yes, Your Honor.
Thank you.
Thank you.
Court does call the case People versus Justin Fuller.
And then on behalf of the people, Your Honor.
And Mackie on behalf of Mr. Fowler, who is approaching. Please state your name for the record.
Justin Foley.
All right, go ahead.
Your Honor, at this time, we request that this honorable court adjourn this matter for 2 weeks pending media discovery.
Public cause conference will be adjourned at objection, March 27th, 2025, 9 a.m. Bond will continue.
Your Honor, may I address bond real quick?
Doubt.
A bond condition.
No, oh, condition. Okay, no,
Sorry.
go ahead. I didn't know where you were going, but go ahead.
Your Honor, as we know, the purpose of bond is to ensure the safety of the community and that our client appears to court, which he has. He has no history or violations of any drug or alcohol use, and in this specific case, no alleged use of alcohol or drugs. We ask that this court remove his testing requirement so that he can work, and it's been hindering with his work to come in randomly to test, and it costs money. Or we ask in the alternative if we could,
He's on a standard domestic violence condition, and that's where his testing is coming out of.
yes, Your Honor.
Okay, go ahead.
I spoke with APA Zenda on this matter, and
How was
she-
that?
Pardon?
How'd that go?
Oh, she was leaving it up to your discretion, Your Honor.
What?
Yes.
Oh, do they have a position? I'll wait to hear from her. Go ahead, I'm sorry.
So we do ask that that condition be removed or at least set on a specific time or day so he can arrange his work around that. And I have a paper here, Your Honor, that shows where he works and the time and everything.
I don't know what I'm supposed to do with that, but fine, I'll take it.
Oh, well, maybe approach actually with it. Please, Your Honor.
If you wanted to approach, you should have led with that. You sit down. You leave her alone. She's fine. Come on. Well. Bellinger was gonna like, and then next thing you know.
Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk with Mike is experiencing what we in the business call a plot hole-sized lull. This is, of course, due entirely to Mike's, let's say, ambitious approach to preparation. And by ambitious, I mean utterly devoid. Yes, the very fabric of our legal system, as represented by this live stream, has encountered a, shall we say, temporal anomaly. A glitch, a hiccup, a veritable vacuum of action. And who is to blame? Why none other than our esteemed yet woefully unprepared host, Mike. So sit back, relax, maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. So to fill the gaping void where insightful legal analysis should be, and due to a lack of any ability to keep your attention, Mike has in his infinite wisdom decided to subject you to this artistic expression. God help us all. Please do not hold Mike accountable for this. Bless his heart, Mike didn't quite foresee these moments of dead air when he planned for this whole thing. He clearly has no idea what he's doing. So sit back, relax, and maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably.
Number one, know what I'm saying? Number one, know what I'm saying? We are the Law Talk with my crew. Number one, know what I'm saying? 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 Number one, know what I'm saying?
was 3/23/25. I'm presuming it was intended to be 3/13/25, signed by all 12 jurors. Forfeiture specification to count 2, we, the jury, find that the state of Ohio did prove by clear and convincing evidence that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio, dated 3/23/25, signed by all 12 jurors. Count 3, possession of cocaine. We, the jury, being duly impaneled and sworn, find the defendant Oshay Lopat Jordan guilty of possession of cocaine as charged in the indictment, dated 3/23/25, signed by all 12 jurors. Forfeiture specification to count 3, we, the jury, find that the state of Ohio did prove by clear and convincing evidence that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to the forfeiture of the state of Ohio, dated 3/23/25, signed by all 12 jurors. Count 4, soliciting, we, the jury, being duly impaneled and sworn, find the defendant Oshay Lopat Jordan guilty of soliciting as charged in the indictment, dated 3/23/05, signed by all 12 jurors. As to the foreman, juror number 7, 2 of the dates are 3/13, the remaining are 3/23. I presume that they were signed today in the jury room, is that correct? All right, does either side wish to have the jury polled?
No, Your Honor, thank you.
Mr. Jordan, do you wish to have the jury polled?
No, Your Honor.
All right, thank you very much, ladies and gentlemen. If you go back to the jury room, I'll be back to speak to you in a little bit. That's all right.
What do you know? I've never seen that coming. Thanks for whoever put that in the chat. I kept checking it, but I didn't see it come on.
All right, I'm going to order that a pre-sentence report be conducted as well as a drug and alcohol evaluation. I'm going to set the sentencing for April 16th at 3 p.m. Mr. Jordan, you're going to need to go over, and I'm going to continue your current bond. You're going to need to go over to the probation department and begin the process. The preparation, yes, of the pre-sentence report and drug and alcohol evaluation. Do you know where that's located?
Oh, no, where's that location?
It's in the Lake County Jail building on the 3rd floor. You go up, take the elevator up to the 3rd floor and check in up there. They'll be expecting you.
Okay.
All right. Anything further from the state?
Nothing further from the state. Thank you.
Mr. Jordan, anything further from you before we adjourn?
Could I also ask for a medication penalty? How do you pronounce that?
Mitigation penalty. A psych evaluation mitigation for mitigation of penalty.
All right. You know what I'll do? I'll order a psychological evaluation, which will encompass the drug and alcohol evaluation also.
All right, thank you.
All right. Anything further?
Remind me of that date again for
4/16 at 3 p.m.
All right, thank you.
All right. We're adjourned.
Well, there you go. What do you know? I actually made it for the verdict. I think most of it. I missed a little bit of it, but it doesn't matter. It's guilty on all fronts. I'm shocked like the rest of you. I thought he was going to ride that Charlie Brown shirt to victory. when the ladies came in to testify against him and were credible as hell, and then he reiterated their testimony on his cross-examination, putting himself in the room with drugs and a gun. He actually testified for himself without actually testifying. And his prior conviction came in because it was an element of the offense. So, I mean, he might as well have just taken the stand. He still would have been convicted, but it would have been, you know, it would have been more fun for us. It's odd because, okay, so I actually did do a playlist, and I got into this at 1 o'clock in the morning on Saturday. and he had a court appearance. It was sort of the pretrial for this trial. And I don't know that that's the case or not. I don't know if he's going away or not. That's a good question. But I mean, he might be in already, or might not. I have no idea. But it all started with that, and he was full soft sit. He did it a couple of times during the trial, but not much. He really tried to defend himself in a regular way. So I can't, like I said earlier, I came to this trial for the soft sit crazy, but stayed for the throuple with the hookers, But there's the end. I'll cover the sentencing if it's on. I'll cover the sentencing. But that at least concludes the trial phase of 2 girls, 1 fez. Right there. I got a little cranky. With the sound issues I was experiencing. That was rough. I wanted to do this trial. First of all, I thought it would be done in 1 day, but even 2.5 days is fine. It was so frustrating because it was there. He was spewing stupid, but we couldn't hear it. But we got the good stuff. We heard from all participants in the throuple. It was fun times. All right. So we actually got the verdict. Like I said, I will do the sentencing if it pops up. Thanks for coming out. I appreciate it. I'll see y'all soon.